Hi, thanks for using my court coach. I'm Sarah, and I will be your instructor today as we discuss the Family-Centered Case Resolution Order, also known as Form FL-174. In family law, there are generally two types of hearings. There are substantive hearings, where the court makes actual orders regarding certain issues that have been brought to their attention. There's also procedural hearings, where the court just wants to get a status on the case. Oftentimes, the procedural hearing is referred to as a family resolution conference. And family resolution conferences are set by the court to check in on a case, see what the court can do to assist in moving a case along. And sometimes at these family resolution conferences, the court may make certain orders, and they may order a family-centered case resolution plan. If they do that, they may ask you to prepare a family-centered case resolution order, which is what this form is. If you have to do that, then per usual, you want to fill in your identifying case caption, identification information at the top. Below that, you're going to list the date of the hearing and the name of the judicial officer who heard the hearing and the department number where that hearing took place. Below that, you're going to list all the parties that were present. If that's petitioner, respondent, other party, check whatever appropriate boxes to identify those people that were present. And if there's any attorneys present, check those boxes identifying the attorney for which party was there and the name of that attorney. Oftentimes at a family resolution conference, the court is going to set a future hearing date so they can check back in on the status and see if any progress has been made. So field number 2 would have you list the next court dates and the type of hearing. So it's either going to be another family-centered case resolution conference. It could be a status conference. And that kind of depends on which county you're in. Sometimes that's something different, but oftentimes it's the same thing. Or it could be something other. For instance, if it's agreed that you guys are next going to go to a mandatory settlement conference, for instance, then you would check the box that says other and specify what that hearing is, and again, give the date, time, and department number. The next field has to do with the status of settlement. If the case is settled and the court is just giving you a deadline to submit that settlement agreement by the next hearing date, then you would mark box 3A. On the other hand, and as previously stated, if the parties do agree to talk or participate in settlement negotiations or discussions, you would mark box 3B and again, provide as much information about that as you know. If there is a mandatory settlement conference, for instance, again, I would probably list the date and time that that's supposed to take place and any other details about when briefs are to be exchanged. If there is a domestic violence case and the parties do wish to participate in settlement discussions, but there's some concern about the parties being in the same room as each other, then the court can order that the parties have separate sessions for that settlement discussion, in which case you would mark box 3C. The next page has to do with the disclosure forms. Before the court can accept any sort of settlement between the parties, there is a set of financial disclosure forms, collectively referred to as preliminary declaration of disclosure forms, that the court needs to ensure are exchanged. And then there's a form, the FL-141, which is also known as the Declaration Regarding Service of Declaration of Disclosure and Income and Expense Declaration, that has to be filed with the court. So if that has not been done yet, the court may order that one or both of the parties exchange those forms and give you a deadline by which to do so. So if the court does do that, then you would mark the box identifying which party has been ordered to complete those forms and then the deadline that the court gives you. There's same set of forms is also required at the end of the case, or the parties can choose to waive it. If the court finds out that there's a settlement, but again, this final set of declaration of disclosure forms has not been exchanged, then the court may order those to be exchanged or the parties to sign a waiver and again give you a deadline. So if the court does order that, mark box 4C and list the date that the court gave you by which that needs to be done. In certain cases, the court may just order the parties exchange current income and expense declarations. If, for instance, if only financial issues are at center. So if the court does make that an order, just like with box number 4, identify the party who's been ordered to provide the document and list the date by which they need to do so. Before a court can set a case for settlement, the court needs to know that discovery has been completed. So if a representation is made that discovery is complete, you can mark box 6A. If the parties indicate that they're currently in mediation and for that reason discovery has been suspended, you could mark box 6B. If the parties have not yet completed discovery, the court may come up with a discovery plan for the parties and state specifically depositions need to be done by such and such date. If there's a request for production of documents, that needs to be done by such and such date. So if they go into that level of detail, then you would mark 6C, identify the party who has to complete the discovery task, what that task is, and the date it needs to be done by. And a court might do this just to move a case along. If there are experts in the case, and those are people that are retained and have a certain level of expertise to assist with an issue, then you would want to list the name of the expert and what issue they are addressing. If there's an agreement about how that expert will be paid, that would go in 7B. If the court determines this case is appropriate to set for a trial, then in 8A, you would list the date the trial is set for, the time, and the department number. If the court finds the case is not yet ripe for a trial, but is ripe for a mandatory settlement conference, in 8B, you would list the date, time, and department number. Oftentimes with settlement conferences, there's a brief that each party has to prepare that outlines their basic positions and it provides any evidence in support of those positions. If there's a deadline by which those need to be exchanged, then 8C is where you would list that deadline. If the matter is set for a trial, the court is going to ask for a trial estimate. How many days do you think you need to present your case in total? And so that would be listed in 8D. 8E, you would list the issues set for trial. If it's child custody, child support, property division, etc. This is where you would list those issues. If there's any other court orders that the court makes related to the trial setting, and that can be a whole variety of things, then you would list that in 8F. Finally, if there's any other orders made at your family resolution conference that don't fit into any of these other categories, you can fit that into 9 and list that there. If there's any attachments to this form, list the number of pages attached to line 10. This is a form that needs to be signed by a judge in order to become formalized. It doesn't mean that the orders that they make that day don't take effect immediately, because they do, but the order won't be a formal order until it is signed by a judge. So this will need to be submitted and presented for the judge's signature. I hope you found this helpful. Good luck.